recommendations and indicate how they will address matters arising out of the said recommendations. Cabinet asked the Inter-Ministerial Committee on Land Reform and Agriculture to coordinate departmental inputs and send a report to Cabinet by September. I'm the first to indicate that unfortunately this deadline was not met, given the work that a number of departments were undertaking to look much deeper into the recommendations and its implication to their relevant departments. In the first meeting, the IMC noted that the panel had not concluded its consultations with traditional leaders before tabling their report to Cabinet in July. The IMC then advised the advisory panel to continue to undertake this process in order to ensure that all relevant stakeholders have expressed their views on this important matter. In the examination of the report, a number of departments noted that some of the issues raised or reflected upon by the advisory panel were matters that they were already addressing as departments. Therefore, in large measure, the recommendations were seen as the affirmation of the work already being done and also sharpening and giving alternatives on how some of these processes can be undertaken. The recommendations also made proposals on policy and legislation gaps, such as the policy on land tenure that will address communal and traditional land tenure in South Africa. Also, some of them recommendations spoke to programmatic interventions that are required to address matters including coordination among spheres of government. Almost all the recommendations were accepted, and government will address issues raised in these recommendations through implementation of them in respective ways. There were some recommendations that were not accepted, not because the issues raised were not important, but such recommendations require further engagement, which are of a policy nature, and as such, particular processes will need to be undertaken to arrive at policy or legislative system which the intent of the recommendation seeks to address. On the agreed recommendations, the relevant departments will develop action plans to ensure implementation is undertaken. The IMC from time to time will receive reports on progress on the implementation of such recommendations. I will highlight some of the recommendations which were not supported by Cabinet and indicate the reasons why. The panel recommended that land reform must be informed by an agreed vision for agrarian reform. The view of government is that the current white paper on land policy of 1997 is still adequate in its application. It covers broad areas of land administration framework, as well as defined approaches for land reform to address unequal land ownership patterns in our country. It also creates the framework for tenure reform policy. The white paper also appreciates that land reform not only covers agrarian reform, but need to address a variety of land needs in our country, such as housing. It therefore cannot be true, in our view, that land reform must be informed by an agreed vision for agrarian reform. On the contrary, there is an operational vision that has been used since 2002, which actually gives a vision on South African agriculture. And this was developed through the strategic plan for agriculture in South Africa, which was developed in the year 2000. And the vision reads as thus, I quote, "A united, prosperous agricultural sector for South Africa." This vision acknowledged that the scale and size of operation that needs to be supported by various land use pattern will actually be accommodated. This element is covered in the current proposal, and therefore a review, given the challenges of climate change, may merit a development of a new agricultural reform vision or agricultural sector plan as it is being developed by the department. In the context of that recommendation, the proposal was really seen more to address the issue of size and scale of different farm sizes in which different producers will participate. And our view is it will need to be broader than that, but that would not necessarily be informed by a kind of land reform system that the country undertakes. The panel proposed significant measures to unlock urban state land for affordable housing and the creation of a more inclusive towns and cities. The recommendation, I must say, is broadly supported. However, the challenge is with respect to certain mechanisms that are being proposed by the panel as interventions, where government feels we might need to actually do a little bit of investigation of some of those interventions, and therefore we may not necessarily approve or support all of those in its entirety at this stage. The panel proposed the review of the Office of the Valuer General and its functions in line with the Property Valuations Act, which is under the Department of Public Works, to ensure that compensation determined in the event of expropriation for land reform purposes is just and equitable and not purely market value based. This must be aligned with the compensation being proposed by the panel. In our view as government, actually the existing OVG Act is in line with the Property Valuation Act of Public Works, which is under Public Works. However, we all appreciate that though some of the proposals with regards to how you determine just and equitable is actually what is the current debate in the current parliamentary process of amending Section 25 that must be made explicit. The panel proposed that government must develop a unified land administration system for the country, proposing to develop a green and white paper that would include land administration as a chapter. The view of government in this respect is that the current white paper does include land administration. However, what may need to be expedited is a unified and land administration system where possible the amendment of the Deeds Registry Act to include the recordal of informal land rights in the former homelands and communal areas in our country, which to date are not actually part of the land registry system in our country. In our view, the proposed new green and white paper on land may be merited, but in our view, it's a long-term program. It does not arrange the immediate challenges that the country faces. The panel proposed the transfer of responsibility for rural development, DRDLR, as it is said, and locate its coordination within the presidency. This relates to rural development program. Our view is that that recommendation is moot. As we know that by the time the panel made the recommendation, a reconfiguration of government departments and ministry in the 6th administration was already pronounced by the president. The panel also proposes an establishment or delegate central authority with clear powers and responsibility to proactively manage state land and ensure that such an authority meet its broad obligations and balance the interests of the potential competing departments. Our view as government is that the Inter-Ministerial Committee on Land and Agriculture, chaired by the Deputy President, addresses what the panel was recommending. And also, if one looks at the composition of the IMC, is not only national government, it also includes local municipalities through the participation of SALGA. And therefore, our view is that this process of the IMC does manage coordination as well as competing needs without removing legislative competence from those who have to undertake specific functions in relation to the aligned mandate. Panel also proposes the establishment of the National Land Rights Protector for managing high-level conflict, especially between the state and the citizens. The view of government is that what the proposed recommendation seeks to address may be covered in the expanded mandate of the land court's legislation that the panel itself proposed in its recommendation that it must be done. And if I may indicate, this is the work that already the IMC had instructed the Ministry of Justice together with departments of land to undertake, to look at the current land claims court and see whether or not such legislation should not be broadly expanded to include all land-related matters. And in our view is that that process will then accommodate the concerns of the panel in this regard. The panel recommended that government should create a land reform fund. The view of government is that the currently may not be merit in setting up of such a fund, because in our view, the optimum and judicious use of current budget allocation can still address the required resources for land reform. The other recommendation from the panel is that there must be an establishment of a land and agrarian reform agency. Our view as government is that the new configuration of the department, which now combines land and agriculture and rural development, does address the concerns that the panel might have had when they made this recommendation. The other recommendation related to the land tax inquiry, which is being proposed by the panel. The view of government is that actually such an inquiry was done in the late 1990s, mid-2000. And this inquiry, actually, it's what brought to a legislation in the Municipal Structures Act that relates to the property rates legislation, as well as the capital gains tax. And therefore, at the moment, government's view is that there may not be a need for such a land tax inquiry. In the discussion, Cabinet noted that there are some of the recommendations which may require further work, such as the recommendation that the panel have proposed on the land ceiling. The panel says consideration should be given on the imposition of land ceiling to limit the total area of land that any one individual or company of land ownership, which is antithetical to land reform. Such ceiling must be varied across agroecological zones. The state must be empowered in law to compulsory acquire surplus land and to determine which land is required for redistribution. While as government we note the intent and the spirit of this recommendation, we are of the view that further work would need to be done, particularly that the panel itself, in the body of the report, they do indicate the difficulty that is accompanied by any proposition of the land ceiling and its application. And also if you take the agroecological zone of our country, where the agricultural vegetation as well as your rain patterns are not the same anywhere in the country, and therefore to determine a land ceiling, what may be small scale in the region like KZN around Umgeni River, if I were to make an example, where the land is fertile and you have access to water resources. What is small scale there cannot be small scale in the same extent and size in the Northern Cape, which is very arid and dry. And therefore, to actually have an application where you would have to determine land ceiling in the country may not actually be viable at this point in time. And therefore, the view of government is that this is just amongst one of those recommendations where further work may be required. And I think this is comprehensive enough just to give you the flavor of those recommendations where the state have actually felt, you know, we may not agree with them in its entirety, and also some of them which we think there is further work that is required. Obviously on those, as I said earlier, where we are agreeing work is being undertaken, such as the beneficiary selection policy, which the which Cabinet have approved, and the Department of Land Affairs will be releasing it for comment. It actually deals with the issue of transparency in terms of land allocation. We are also working on the donations policy, which will then guide those who would want to donate land. The issue of inclusivity in terms of ensuring that we deal with spatial planning, again, that has been addressed. The National Spatial Development Framework has actually been released for comment, and I think it does address that issue. And also in the way in which government is looking at targeting land for residential purposes, for housing in particular, will address some of those recommendations that are being made. Thank you very much, Reggie, and to all of you here in Pretoria and in Cape Town.
Thank you very much, Minister. Colleagues, we'll take a round of questions. Let's start with Pretoria. One, can you take 4? 1, 2, 3. Okay. 4.
Minister Nika van Buurik, Landbouweekblad. Were the recommendations in the alternative report by Creek Consultant, were they considered at all?
Okay.
Cindy Swatwala from Newsroom Africa. I see here that you also mentioned that you establish a national land rights protector. In terms of the land rights protector, will this particular Chapter 9, will it fall under the Chapter 9 institutions and have the same rights, or will they have more rights, such as some commissions? And then secondly, what does the adoption of the 60 recommendations essentially mean? Is there like a rollout of when and how some of the things are going to be implemented? And secondly, maybe I might have missed it, I'm not sure, but in terms of the Ngonyama Trust, what exactly has been resolved? Because the panel suggested doing away with it.
Okay.
Mr. Mabuza from ENCA. I just wanted to touch on the recommendations that were not supported by Cabinet, especially on the Agrarian Reform. I understand that has to do with redistribution of agricultural land. I just want a better understanding. Is government not pursuing the redistribution of agricultural land, or is it basing it on the 1997 policy which hasn't been effective yet?
Yes, sir.
Yeah. My name is Sibiwa from Independent Media. Minister, I first wanted to ask, are you able, even though you are saying public comment is still going to be sought, are you able to actually, broadly in principle, tell us what is the nature of beneficiary selection in terms of the people who are going to be beneficiaries? And secondly, you are saying in the recommendations that were rejected or that were not accepted by Cabinet, is the proposal for the establishment of a land reform fund, and you are saying it can be addressed with the budget, not Cabinet. Are you indicating that we have enough fiscals to actually fund land reform?
Thank you very much, and thanks to all the members who have raised their question. If I were to start with the alternative report, yes, Cabinet did look at the report because it was part of the assessment that was done by the department. You'd recall that a majority of the difference between the panel and those who came up with an alternative report related in large measure on expropriation without compensation, an issue which currently is being undertaken by the parliamentary review process. And I hope those people who have got a different view will make comments in the draft bill that has been made available by that ad hoc committee that is working on them. So it's one of those recommendations where there was really no acceptance, rejection, or even noting, because it's work in progress that is being undertaken by another sphere of our state, which is the legislature. Obviously, if you look at the recommendation of the panel, when it comes to that matter, it acknowledged the different views that are being expressed by a number of citizens and scholars, even legal practitioners, about the applicability of expropriation without compensation. However, what the report, as you will see in it, of the panel, they do make propositions of where they think what types of land may ready themselves for expropriation without compensation. Again, this is where the alternative report make their intentions clear, that they do not support the approach, neither do they support land that has been held, for a long time unused by people, that it must be subjected to expropriation without compensation. They also indicate that game farms, for instance, should not also be applicable for land that is expropriated without compensation. But I'm saying on all of those, you couldn't take a decision, because that's matter under the debate at the moment, and it's open currently for everybody to make their views known in that legislative process that Parliament is undertaking. With regards to the land rights protector, I think the correction, if you will see in that report, it's the recommendation of the panel, which government is not supporting. It's one of those recommendations where government feels the intent and the spirit of the recommendation feels can be covered in the expanded mandate of the Land Claims Court, where government is proposing a land court bill. You'd recall that in the Restitution Act of 1995, it sets up the Land Claims Court, where people can actually go to court for adjudication of their claims. It also allows for labor tenants and farm workers in particular, if they are evicted, they can actually go and appeal to the Land Claims Court. The Land Claims Court also deal with matters that cannot be addressed in terms of negotiations with respect to land restitution. So its scope and mandate was very limited. That's why if you look even in the appointment of judges, they only have 5 judges who are also not full-time. It's not a division by itself. So what has been proposed by the panel is that we should rather look at a land court which can deal with a variety of land matters. And we're saying that matter can be best addressed there. And as we speak, even the IMC, before the panel even released its report, it's one of the areas that they had mandated the Department of Justice to undertake, to actually look at the possibility of an expanded mandate of the Land Claims Court, so that it can be a land court addressing the issues of land, and also dealing with issues of mediation, looking at an instrument such as in the labor relations dispensation, which allows for mediation such as CCMA, because some of the land court disputes are not necessarily matters that require litigation all the time. Others may need a mediation process. So that process is being undertaken as we speak by the Department of Justice. And therefore, Cabinet actually felt maybe we can't support that proposal as of now. The other issue that you raise, what does the adoption of the other recommendation mean? What it actually means is that those recommendations that Cabinet have adopted are actually going to be implemented by the various departments that are impacted upon by those recommendations, and majority of those would relate to the Department of Agriculture and Land Affairs, Department of Housing, to a limited extent, Department of Justice, so, and also I would say Department of Environment, because that's somewhere where they also relate to issues of climate change. So those various departments will then factor those recommendations into their program of action. You also are asking what did the government say about Ingonyama Trust. As you recall even in the presentation by the chair of the panel, that matter, they said their proposal is that there must be a review of Ingonyama Trust or maybe a repeal of that legislation. The view of government is that the issue of the Ingonyama Trust actually falls in the broad scope of tenure reform in South Africa, which is not yet concluded, and therefore it will be dealt with in that category of addressing the issue of rural tenure in South Africa. Actually, we do not yet have a definite policy positions on tenure reform in South Africa, whether we're going for a tenure system which is freehold and title, or we go for a multiplicity of tenure system. In the current moment, you have got a dispensation where freehold tenure and title, people can hold their land in their name and right. But the rural South Africans are still governed under multiplicity of legislation which puts the Minister of Land Affairs to be the custodian or a trusteeship on their land, and they're not holding them in their name and right. And that's the issue, in our view, that it's immediate, that must be addressed. That is why we are saying, in addressing that issue, you will require an amendment of the Deeds Registry Act to ensure that you can record those informal rights so that they are part of your land administration system in the country. With regards to agrarian reform, no, we are saying if you look at the body of the report, the issue of agrarian reform, we do agree with it, and it's a program that we are undertaking as government. The release of state land for agricultural development, acquisition of land as it is being done by the Department of Land Reform currently addresses that very issue, particularly for those who would like to be the claimant to actually acquire land for agricultural development. Land bank funds, people who would like to acquire funds, to acquire farms for productive purposes, and government in its support of those who want to become farmers, and even the building of smallholder farmers to become commercial. It's the program of government. But what we were saying in that report is where an assumption is made that currently you don't have a vision for an agrarian reform or agriculture in South Africa. So that's what we were saying. You can't do that by reverse as it is proposed that, agrarian reform must inform land reform, kind of the wording in which is there. And we're saying, no. In our view, land reform in South Africa will cover agrarian reform, cover human settlement, and even land for industrial development. So in our approach, land reform in South Africa just don't talk into agriculture alone, but it talks to a variety of land needs that are there and what South Africans would like to acquire. With regards to the beneficiary selection policy that is being released by the Department of Land Affairs, what occasioned that, even what the policy, the recommendation of the panel is saying, is at the moment, nobody can say from an outset, how do I acquire or how do I become a beneficiary for land allocation, except to say you apply in the Department of Land Affairs, you satisfy the criteria that maybe you need land for agrarian reform, as the other gentleman was saying, or you go to Department of Housing for land. But as to how the transparency in the adjudication of who qualifies has not been quite open, and that's what the beneficiary selection policy seeks to address, so that any South African, you will know that this is the criteria around which I'm measured whether I qualify or I don't qualify. The last one, Land Reform Fund. Our view is that creating a special fund at the moment may not be an appropriate one. If you look at the allocation in the budget of land affairs, budget on agriculture, which supports farmers, budget on human settlement, which supports housing, we think its judicious application will actually enable us to undertake the work that we are supposed to do as government in respect of land reform within the other competing needs that are there. And we don't think addressing the issue of funding necessarily require a special fund dispensation that would only be for land reform in our view. I think I've answered all the four.
Thanks, Mr. Cape Town. Any takers in Cape Town?
No questions at this stage.
Okay.
One moment, please.
Good morning, Minister. Paul Bekiacha from Bloomberg. So, in the light of this report and what the government, is government satisfied that the land reform process in rural and urban areas is on track to meet its own targets?
Okay. Any takers in Pretoria? Yes, madam.
Leila Magnus, SABC Radio News. Minister, I would just like to know in general, if you can tell me, yes, Leila Magnus, SABC News Radio. Minister, I would just like if you in general terms can tell me, once these recommendations are implemented, what do you as government hope will be the outcomes? How will South Africa, what will it look like once these recommendations have been implemented?
Okay. PNC?
Just to add on to that, maybe take the viewers that are watching now, Minister, into confidence of how, I mean, it was the biggest promises, election promises. How will land expropriation without compensation look like? What can they expect? What parts of society will be expropriated?
Last one.
Minister,
Yeah.
I also wanted to ask, given the fact that, I mean, since 1994, one of the biggest problems of government has been the issue of people wanting to claim their property rights in communal land areas, especially in rural areas. And people, actually, some of them taking comfort together with traditional leaders about the arrangement that they have. And some of these complaints about the government's inability to actually assert the rights of people who want to own their properties in the rural areas. Actually, it has been exacerbated by the passing of the bill now, the Coincident and Traditional Leadership Amendment Act, the one that has been recently passed, which some say traditional leaders are being given rights, over land. I mean, they are given more rights, more land rights than ordinary people who are actually living as subjects under them. Has this report actually assisted you in terms of navigating the difficulty that government has been having in terms of actually balancing the rights of traditional leaders over communal land and the individual rights of South Africans who are actually living in those communal land areas?
Okay.
Thank you very much, and thanks to the ladies and gentlemen for their questions. If one were to respond whether the government is satisfied that this report will assist in government meeting its targets, and I'm not sure what one would say are the targets as we speak. Currently, there were targets that were put in the RDP, which were very ambitious, that government would have done this in 5 years. It wasn't met given the complexities that are there. What I would say is that the recommendations coming out of the panel and the work of the panel is helpful in a sense that you had somebody externally looking inside government, looking at where the weaknesses are and making recommendations on how we could address those recommendations. And I think some of the proposals that are being made in the recommendations will assist in the coordination in strengthening of the institutions to ensure that the delivery process in respect of land reform is actually undertaken with better speed and coordination. The other legislative arrangements that are being proposed, I also think it would actually assist us in giving clarity on a number of areas that have been a bit of difficulty for government before. So yes, it will assist government to ensure that we deal with the issue of skewed land ownership in our country, which is the legacy of our past. What will it look like? I would say all of us in South Africa would like to see a very inclusive society where the issues of inequality, even in terms of land ownership, access and use, are addressed. And it is my view that if we do our work as government, also working with the private sector, and particularly those who have been willing to make contributions in this important issue, we will address a better non-racial, inclusive and non-sexist society. Because one of the important issues that the report also raises is the issue of access to land by women, given what we all know in terms of the patriarchal systems and their nature in our society, where even now you'll find that in some communities, women cannot access land in their own right. And what the panel has actually indicated is that government in its land reform process should really address this issue of equity when it comes to gender. What will land expropriation without compensation look like? I think I'm like yourself, because none of us have actually undertaken this process in our country. We do have an Expropriation Act of 1975 rather, which is under the ministry, or rather administered by the Ministry of Public Works, and it's under review. That Expropriation Act actually dealt with giving powers to government to expropriate land for public interest. If I were to use a simple example, is if a government would like to build a public road, which will be the benefit for all society, they would actually expropriate and give the compensation to the person who has been, whose land has been expropriated, and it defines the steps that must be followed. It also allows the person whose land or housing has been expropriated to actually go to the courts if he or she is not happy with the compensation. We all know when the Gautrain was being built and where it actually affected some of the residences, those members were actually able to get compensation. But what that legislation didn't, and it wouldn't have been able to address at the time, is the issue that relates to public interest, which talks to land reform. And this is where the debate has been in Parliament last year and continues in terms of the proposals that are being made in the amendment of Section 25. Because the current Constitution actually says even where you expropriate in the public interest for land reform purposes, it defines how you arrive at a compensation. And what the review, taking into the work that was done, consulting society about the need for amendments so that you can factor for expropriation without compensation, or as it is put in other jurisdictions as nil compensation, is what I think at the moment all of us are grappling with. To say, how do you arrive at a point where you can say, I will expropriate this piece of land for nil compensation? So you'll have to indicate what values are you taking into consideration. In Section 25, it says you need to look at the history of acquisition, you need to look at the investment that the state had made in terms of the subsidies that were given, and you discount that, and then you come to different determination of just and equitable. And this is what has been at issue as to how do you arrive at. And we think the current process that is being undertaken in Parliament will therefore guide all of us. So that would be my answer in respect of the question that has been answered by the learned gentleman or lady, I can't remember. Rights over communal land, particularly how do you balance the issue of giving, let me say, protect, affirm the land rights of individuals under communal or traditional areas? That's the question you are asking. How does this report assist us to arrive at that? I would say it doesn't in its entirety. What it says is that this is the work that government must undertake because it falls under your tenure reform, and it's about tenure security. You'd recall that in the mid-2000s, this process was undertaken through what was called the Communal Land Rights Act, whose certain sections were actually nullified by the court. It was trying to deal with exactly that balancing as to how do you ensure that people can have their rights affirmed and protected in law in those communal areas, while at the same time it appreciates the coexisting rights at a community level in those communities. So that debate is not resolved. Actually, it is one of the issues that the traditional leaders have also raised for debate in the proposed land summit that they would like to have, so that they too, with their communities, can engage government as to what is the better dispensation. There had been a call by others to say, why don't you go for titling across the board so that each and every homestead has its own title instead of tinkering with this issue. The others are saying, okay, but how do you then deal with communal land such as land for grazing and farmlands? Do you put it under a separate title of the community, and how do you administer those? And I think that's what South Africa, in my view, has to address. In other jurisdictions, such as Botswana, Tanzania, and others, they've actually addressed these issues in the way that would appeal in their dispensation. Some fears that has been expressed in terms of titling in rural areas, which has been expressed by others, is that if you go for titling and giving people full title on their land and they start to transact the land, are you not going to end up with landless communities? It's an issue that is debatable, obviously. But I'm saying in respect of the report, it's not definite on those matters. Thank you.
Okay, colleagues, this is the last one. Take a look. Last round.
No, thank you. Not necessary.
Let's take this.
Just to follow up on that, Minister, I'm actually quite happy that you started traversing into that area. You mentioned earlier that the debate has not started in terms of a unilateral or a multilateral rights system.
Yeah.
So my question is, from the panel of experts, they kept leaning towards a more multilateral, that people need to have a rights, that a right of use and the likes of those portions of land, so that not so much power is given to the trustee at that particular place, like the Ngonyama Trust and the likes, even though you're saying that as the minister, you're the overarching and have the final say. What I would like to find out is when will the discussion be had and finalized and set to bed as to what system we're going to be using, more so in communal land. And another thing, a follow-up, won't this cause some form of confusion in terms of the deeds registration office, because this is now so many rights to register if you decide to register?
Well, thank you very much. Indeed, as the Department of Land Affairs, we are busy with a policy document which will be supported by legislation, where we have actually looked at various systems that are more or less what we have in South Africa, where there has been multiplicity of a tenural system and how those are governed. And that is what we want to put for discussion and debate, because we can't avoid dealing with that issue in our own jurisdiction as a country, in my view. So it will be an issue for debate, open for debate. I don't think it will cause any confusion in the deeds registry system. Actually, the deeds office had looked at this issue, and they actually feel it is possible to do it even in the current legislation with a few amendments which allow for the recordal of rights. You know, the recordal of rights, in the way in which it is done in other jurisdictions, it's not like where you go and register and then have this surveying of that property, you know, in all its coordinates and the maps and the diagrams. In the recordal of rights, in other jurisdictions, what they will do, even within our Surveying Act, you can still, with minimal amendments, accommodate. Even without amendments, you can actually accommodate the recordal of rights, where you go to the perimeter and you can map it and record it against the individual homestead. But when you want to then register that in title, you can actually do the measurements as you would do in terms of surveying. So it is possible, because what you want to do is the recordal. I think what we don't have in our system today, if you were to go to any rural area, it's historical knowledge that is held by families and communities to say that homestead kukwabani, this homestead belongs to the Msane. But the Msane people can't even tell you whether this homestead, it's half a hectare, it's 2 morgan, it's what. They know they've lived there for years, from generation to generation. Other people will come who may not even necessarily come from this clan, but come and want to associate with this community. In Zulu, it is called ukukhonza, where a person who comes not from that lineage of that clan can actually come and want to associate. And if the community accept that individual is then allotted a piece of land. But again, you know, I always make a joke and say it depends on that day that the headman who is being given the task to measure has long or short legs to walk, you know, and do the measurements and then say, here is your property, which depending on the length of the leg may be different from the one who did it for me who had short legs. But still, it's historical knowledge that is not codified anywhere. And this is what we're saying, even if you do a gradual process where you finally end with the title, it is important to have a recordal system so that we can know the extent of rights that people have over the land where they stay. Thank you.
Colleagues, thank you very much for attending. We have come to the end of our media briefing. Indeed, may go and have Merry Christmas and drink a lot of water.
But don't drink and drive.
A lot of water.
We would like to see you next year. Thank you very much.
Thank you very much, colleagues. We are going to have another, okay, colleagues.